wish to address the Planning Commission, please come forward and recognize and provide your name and address on the sign-in sheet. Please begin remarks by stating your name for the benefit of the commissioners. All remarks are to be addressed to the Planning Commission, not to anyone else in the room. At this time, I ask that all cell phones, Blackberries, PDAs, or any other devices that might disrupt this meeting, please either be placed in silent mode or be turned off. The roll call, Ms. Zarnicki.
Ms. Cruz? Here. Mr. Edmonds?
Here.
Mr. Gottlieb? Mr. Hudson? Mr. Krent?
Here.
Mr. Danzica? Mr. Shefke?
Here.
Mr. Stratt?
Here.
Mr. Tagle?
Here.
Quorum present. The next item is the approval of the agenda. Is there a motion to approve the agenda?
I'll make a motion to
Yes.
approve.
Mr. Shefke, second by Mr. Stratt.
Mr. Edmonds?
Yes.
Mr. Krent?
Yes.
Mr. Shefke?
Yes.
Mr. Stratt?
Yes.
Mr. Tagle?
Yes.
Ms. Cruz?
Yes.
Motion passes. Third is the minutes of the November 11th, 2014 regular meeting.
I'll move that as approved.
Thank you, Mr. Krant. Second? Mr. Shefke?
I'll second
Mr. Gottlieb? I'm sorry, Mr. Krent?
it. Yes.
Mr. Shefke?
Yes.
Mr. Stratt?
Yes.
Mr. Tagle?
Yes.
Ms. Cruz?
Yes.
Mr. Edmonds?
Yes. Item 4 is public comment for items not on the agenda. Seeing no one in the room, we'll move on to item number 5, the Zoning Board of Appeals report.
And there was no one in the room for that either.
Okay.
We didn't have a meeting
Didn't have
because there
a
just
meeting.
was no agenda items to
Okay.
be heard that evening.
Okay, number 6 is Downtown Development Authority, Mr. Savidan.
There was no meeting in November.
Okay. Number 7, Planning and Zoning report.
I keep telling the planning commission that there's 5 or 6 restaurants that seem to be ready to fall on Big Beaver. So
Said 7.
did I say 7? Okay.
Yeah, you did.
And so Ben and I, within the last couple of months, been having a lot of dialogue, a lot of meetings, and then like nothing. So we're waiting. We're kind of in a holding pattern. It just maybe it's a pre-Christmas kind of dip down. Where we're just kind of waiting, and things will ratchet up again, getting ready for the construction season. So not a lot exciting to report. We're just waiting right now for the
Okay.
applications to drop.
About the Big Beaver PUD, anything new on that?
My understanding, the one that we were working on.
Yeah.
Yeah, my understanding is the person who was interested has walked away, and the owner's now looking to try to market it to someone else.
Okay. It's going to be flipped.
If you remember though, when we did have the last meeting with the planning commission, and
Yes.
the planning commission advised them that they needed to pay more attention to the residential component and the relationship between residential and commercial, and they came back with an updated rendering that was really good. And they listened to everyone, and I was really excited because it seemed like we were close.
Right.
But then he stepped away, so we'll see.
Interesting. Okay. Number 8 is the zoning ordinance text amendment, file number ZOTA 247, oil and gas extraction. Just going to start with this.
Well, I'll introduce it and we'll kind of tag team. This was brought forward as suggested by the Planning Commission, which I think is a good suggestion. It affords us an opportunity to come up with regulations and determine where it's appropriate for these types of facilities. So, at the request of the Planning Commission, we talked about some concepts at the last meeting, or 2 meetings ago, and then Ben drafted some draft language. It's not in ordinance form yet. The city attorney has not had an opportunity to go over it, but we wanted to make sure the Planning Commission was okay with this approach. And if they are, we'll put it in ordinance form, and then we'll formally submit it to the city attorney for her review.
Okay.
So I have a very brief presentation that just outlines the ordinance and the ordinance language. So when Brent said that the city attorney has not reviewed it, that's correct. However, Alan has reviewed it, and Alan, I think there was really one substantive change, I think, really. And so I've incorporated that in this. So this is the most updated version based on Alan's review. So why are we doing this? This is an action from the Planning Commission to look at draft regulations regarding natural resource extraction, specifically oil and gas. Part of this is a tenet of the master of the zoning ordinance is the protection of single-family residential properties, and this is encouraging and trying to promote the protection of single-family residential. So here's basically take that whole 7-page ordinance and it boils down to this one slide. So how we've written this is it's permitted only in IB district as a special use. It requires increased setbacks based upon adjacent use and zoning. It requires a minimum lot size of 5 acres. We require extensive fencing, landscaping, and limited lighting allowance. In addition, there is adherence to strict nuisance and performance standard requirements, including federal and state laws, as well as there needs to be a submittal of a detailed operation plan so that staff, as well as the planning commission, can understand how the site is going to operate. In addition, we've added the following definitions to the zoning ordinance, or proposed to add these definitions. These are all terms that are found within the ordinance, and so we need to add those definitions accordingly to Article 2 of the zoning ordinance. Here's the substantive change. When this was, the draft you saw just listed oil and gas well, and these are not permitted, only in special use in IB. Alan has added oil and gas well development, and again, it's a special use only in IB. The setbacks that we are proposing, let me take a step back. So I looked, when we wrote this, we looked at Auburn Hills, we looked at Rochester Hills, and then we also looked at a bunch that were actually in Pennsylvania, Florida, and California. And so these are all kind of the best practices from all those different ordinances, are kind of how we got to where we're here for the draft ordinance. So these setbacks are less in some areas that you'll see in some other ordinances and more than others. It's just kind of a melding between a bunch of different ordinances. So the proposed setbacks that we are proposing are 300 feet from any right-of-way, 500 feet from any residentially zoned or used property, or any property used for religious facility, public or private school, or a hospital. And lastly, 100 feet from any other property line. What the setback is not simply where the oil well or derrick is located, but all the operations associated with that, the oil pad, the development site, if there's any sort of limited on-site storage, etc. Basically, you draw an outline of that, and then 100 feet or 300 feet or 500 feet accordingly. So you might have the separation between an actual property line might be in greater excess than the 300, 400, 500, or 100 feet, but the limitation of where that development well site is what these setbacks have to meet. And lastly, we do require a minimum of 5 acres. Any questions on this? Yes.
Do you know if the 500 feet requirement would preclude any of the 5-acre parcels that are in or near residential? Because when I looked at your map, I was surprised to see there were that many, and in the locations they were in the city. Have we done an overlay to see if that would throw some of those IB sites out, even though they may be 5 acres, they can't meet the 500-foot setback?
We haven't done an overlay of that. It's probably something worth looking into.
Based on what we learned from our other experience about how these new districts meld in with the rest of the districts and protecting the residential, I think that might be a good overlay to see.
Is that because you think the 500, you just don't, is 500 sufficient, or you don't know,
No,
or 5 acres?
not-
You just want to know what property.
I just want
it
to
is?
know if there are, because of that requirement, does it take some of these parcels, these 5-acre parcels, out of the running?
My guess, and when I did the analysis, 5 acres is tight, if not almost virtually impossible, if you have to meet this 500-foot setback.
Absolutely.
And
So-
depending on the proportion of the site, I mean, if it's a narrow, deep
Right,
site,
yeah.
I mean, there's no way.
Right. No, we have not got to, we have not gotten, that's a good point. We didn't because partially because we want to make sure that the planning commission bought in with the 500, 300 before we start applying this, but we can do that in the next update.
Even the 300 feet is length of a football field. That's,
Pretty deep property.
yeah, all right, then.
I was just gonna ask one question related to that 500-foot from any residential. I seem to recall, was it Rochester Hills that had put 1,000 feet in theirs? And then I was gonna ask the city attorney, what is your thoughts about that? Is it just, is that considered exclusionary zoning, or?
could be, if it results in there being no place where you can put an oil and gas well, it could be exclusion.
Rochester Hills has a lot of vacant land. We're not Rochester Hills.
No, I understand.
I mean, we're 90% built out, 99%, I guess.
What about combining properties? In other words, if there's adjacent properties that rights could be obtained, there could be a lot more property open up than just the lots that were highlighted on the computer when I was checking it out.
Yep.
That's correct.
That's correct. Does not preclude you from putting together parcels to get to the 5 acres.
That's always true.
Yep.
Simply.
That's a good point. It's impossible to determine what could happen in the future in terms of assembly. There's always that possibility.
Any other questions about this? In addition to those setback requirements, there are fencing and landscaping and lighting. A 6-foot high fence designed to prevent unauthorized entry. Brett and I went back and forth, should it be a chain link or should it be a stockade fence? I don't think we necessarily care because we're also putting a significant landscape buffer. Because most utility sites are chain link fence, so, and those are really used to prevent entry, so we felt like a chain link would be appropriate for some of these. But in addition to chain link fence, you have to have a 10-foot high evergreen screening around the perimeter of the fence line with a minimum landscape buffer of at least 25 feet.
Question on that?
Yeah.
You're gonna put in the spacing for those evergreens too, between each evergreen? 'Cause
I think we'll fall back probably on the 80% opacity that we have already in the ordinance, so we'll reference that requirement.
And also, it's a special use, so depending on the operation, the planning commission could require
Very good.
an opaque fence. But remember, there is minimal distances from residential, so these in all likelihood are gonna be adjacent to other intense type uses, so the need for opacity maybe isn't there. It's really a case-by-case basis.
Thank you.
And then lastly, exterior light shall comply with the section 1305 of the zoning ordinance, which limits light, especially adjacent to residential.
The one existing gas well that I'm aware of, and I don't know if you folks are aware of it anymore, but over there on the MSU management property, it just has looked to me like about an 8-foot high fence, but chain link fence with the slats through it. But it doesn't have a lot of extra buffering, but it is way back in off the road, that type of thing. But I don't think, have we ever had any complaints on that?
None that I'm aware of.
Mr. Tagle?
What's your thinking about the words to prevent unauthorized entry? A 6-foot high fence, I mean, a chain link fence in and of itself, I don't know if that would stop someone. And are you thinking something more than just a chain link fence? Or if you say that, what was the thinking behind it?
I don't think we put too much thought into the actual term. We can take it out. I mean, if the planning commission wants an 8-foot fence as a minimum requirement, we can put that in. Typically 6-foot standard, and then allows the planning commission to go up to 8 feet through a special use process. That's how it is now, and for other industrial site-like properties, so. But yeah, I don't think we put too much thought into why we put that language in there. It was used in other ordinances, we kind of took it from other
Would
ordinances.
we also add signage? Because I noticed over at the MSU management, when the gas well there's a driveway, just grass, sodded driveway there that's going into it. But there's a cable running across the signage there that says no trespassing. So that might be more effective than necessarily a fence. Just
Look
something
at-
to
yeah.
think about.
Yeah. Any other questions on this?
Anyone else?
In addition, we have nuisance and performance standards. First is they have to comply with section 1206, which details environmental standards. These include noise, smoke, odor, open storage, fire, odors, waste, and vibration. In addition, they have to utilize the best practices as defined by the department, the DEQ. And lastly, we put language in that allows the planning commission to put reasonable restrictions upon operations that to reduce impact upon adjacent properties. So it gives you a little more latitude to ensure that this will not impact adjacent properties. We have a much more detailed submittal requirements for this type of use than we have for any other special use in the ordinance, and this includes an environmental impact statement, hydrogeological analysis, emergency response plan, a reclamation plan. All of these will be reviewed by engineering, they'll be reviewed by the police department, they'll be reviewed by the fire department, so we'll get all the city departments buy-in to all these different associated plans. And I should say, the environmental impact statement, the hydrological analysis, and I believe the emergency response plans are required by the state to be submitted to, so they would be just simply submitting to us what they have to submit to the state as well. And lastly, we do have a detailed operations plan so that we can better understand how the site's gonna be operated, such as site ingress and egress, the haul route map, hours of operation, soil erosion, mud and dust control, noise control, odor, pollution, impact mitigation, and monitoring controls. These will all be put in a plan that will be adopted as part of the special use, so that we actually have documentation on how they're planning on operating the facility. Anything that deviates from the operation plans can be grounds to revoke a special use permit, so we have additional controls over the operations. I think that's it.
Mr. Tagle?
Did you guys have any discussion with the engineering department as to what their role would be in this use?
We haven't yet,
Okay.
but that'll be a next step. We just wanted to make sure we're on the right track.
Yeah, and our engineering staff is very capable, but I'm guessing some of this stuff, it will be a little bit outside of what their specialty is, and so similar to what we do for many projects, they have the ability to outsource or bring in an outside consultant to do reviews, and so I wouldn't be surprised if some of this stuff, if we actually do get an application for this, they wouldn't outsource or bring in somebody else to review a lot of these documents, a lot of these submittal plans.
Sorry.
Mr. Stroud?
You wouldn't have any problems with there being higher than a 6-foot high fence.
Whatever the planning commission desires.
Well, the reason why I say that, I think that, at least I'm familiar with one client that I have that has some OLL, they're concerned about the protection of not having anybody come in and do any damage to it.
Right.
So they may be interested in actually putting a higher fence in than what we're requiring.
Or
For that
camera,
reason.
even security cameras.
Yeah.
Yeah, the 6 foot was just a minimum.
Which.
Yeah, sparks right next to gas.
High voltage.
Voltage, yeah. Yeah, the 6 foot was just a minimum, doesn't mean you can't go higher, or the planning commission can't grant a higher fence height.
We can't, or they can't?
The 6 foot's a minimum, planning
Minimum.
commission,
Okay, good.
planning commission has the ability to go higher.
Okay, good.
if need be.
Mr. Savage?
We didn't put the map up, but you've all got on your screen. So, Mr. Taylor, what we'll do is, if we get consensus on the numbers that we talked about, is we'll update the map
Okay.
with that information, so we get a kind of a reality check. I'm looking at some of the parcels, like for what the airport. Probably not gonna be dedicated entirely to this type of extraction operation. However, the one we have is at the MSU,
Right.
facilities, which it's nice, probably some nice side revenue, right?
It's been there years. I think.
Absolutely,
Yeah.
years and years, so you never know.
Can I say something?
Mr. S-
There's quite a bit of difference from what I understand, and I'm not talking from the point of knowledge between extracting, oil and having a gas well. Because a gas well, is a lot less evasive to the atmosphere or anything else. I know one time my great-grandfather over by the zoo was drilling a well for water, and he had gas and supplied his store and supplied 2 of the neighbors' houses for years till he died. So there is a lot of natural gas and oil under these populated areas, and some of them is fairly shallow, but I know when you come to oil wells, and I've been around a few of them, they'll stink for a long ways, where gas gas well, there's no smell with, a gas coming out of the ground, they have to add the smell to it, so, you know, you're gonna have a lot less problems with actually a gas well, you know,
Mhm.
natural gas well than you will with oil, so, are these going to fit both scenarios, both natural gas and oil?
It will, and you raise a good point, but one of the things that the language is also intended to regulate is the activities associated with those operations. So if it's, although the smell is less with natural gas until you put the additives in, there's still the trucks and the day-to-day operations and all those other secondary impacts that we want to regulate, so.
And what are the odor requirements?
They're outlined in the ordinance, I can pull it up.
Interestingly, we still have there's two properties zoned IB north of Big Beaver.
Yes.
There's one on Rochester and there's one on Long
And
Lake.
what are those two?
One is the Goodman property on Rochester, and the other one, I forget the name of it.
I didn't realize that was IP.
Yep.
You want me to read it out, Mr. Edmonds?
I'm sorry?
Can we read it out loud, or?
It doesn't matter, I'm just looking for some kind of comfort level that we are protected.
Odor, in odor, it's typically a nuisance type scenario. It's kind of you smell it when you smell it. Odor, any condition or operation results in the creation of odor of such intensity and character as to be detrimental to the health and welfare of the public, or which interferes unreasonably with the comfort of the public, shall be removed, stopped, or modified as to remove the odor.
Who determines that? Sorry,
It's like it's a nuisance type issue, isn't it, Alan?
Pretty much. If
so
they-
that
yeah.
would be
In
the
the
code
court.
enforcement people?
Code enforcement, and then they would.
It
You're a
would literally
hearing
be the
officer.
smell test.
Well, I'm just thinking it's gonna be neighbors complaining.
Absolutely.
Yeah.
That would be a,
Again, if you're only 500 feet,
Yeah, it's hard to put specific standards.
Oh, yeah.
You know, it's like, you don't have like a certain level of smelliness or something that you could
And
quantify, you know.
yeah, the ordinance does require an odor plan, odor control plan. So, they'll consider such as winds and what the prevailing wind direction is, and what houses are in that direction, et cetera. So, those are things that will be reviewed by the operation plan.
It's so difficult to regulate
Oh, I know.
every
You can't
odor
do
because the
everything, yeah.
intensities are different and.
well, and with it being special use, that does give us quite a bit of control and authority. But I know that was one of the issues in Auburn Hills, I think in Rochester Hills, these were made the newspapers, was the number of loads of oil that could be leaving a site. And I think they might even put in restrictions for that. And operating hours, when they could do it.
Mhm.
Mr. Craig?
couple thoughts. One is, on page 4 of our agenda item here, it says, referring to the brine, the mud, slush, et cetera, to be used in producing the well, it shall be under supervision of the state supervisor, well safety, et cetera, but it says, and properly dispose of to prevent infiltration of or damage to any freshwater well, groundwater, watercourse, pond, lake, or wetland. Now, when they're injecting these chemicals, and I don't know what they are, into the ground, how can they even hope to say it's not gonna affect groundwater? They're not gonna put in, let's say, 1,000 gallons of this and then take out exactly 1,000 gallons out again. Some of it's gonna be left, and some of it can, migrate over into fresh water. So it's kind of a tough one.
Is that enforced by the state, the DEQ?
Typically, that's, the state DEQ and the supervisor of wells actually monitors that.
But I don't see as a a remote possibility that you can pull out all the stuff you threw in the ground. It's physically impossible. So I don't know, I'm glad it's there, it says that, but I don't know in practicality how that would ever be accomplished.
Maybe it was.
Yeah. The other thought was, if you don't mind, the horizontal drilling. Now, how far beyond that 5 acres can they go horizontally?
Technology-wise or legally?
Legally.
I think legally they can go as far as the technology allows them because they're, and this is getting into legal area where I'm not sure I want to touch, but they have rights to oil. If they, Alan, you want?
I'm not even sure of the answer yet, because it depends on who owns the subsurface rights. In many cases, we don't even know who owns the subsurface rights. It's an issue we'd probably have to research a little more.
Didn't we talk at one of the last meetings, discussion about this, that you have to submit a reinstatement of your plan?
Mr. Hudson mentioned that,
Yeah. I mean, we think
But I'm not familiar with the.
Mineral rights.
But
The
you
mineral
have-
rights,
But you have to renew it.
yes.
How often is that?
I forgot.
It's 20.
20 years?
That's my recollection of what Mike said.
Okay.
But they could drill thousands of feet away.
Okay. I just wondered if there was anything in our ordinance proposal to limit them, to go to the far reaches of the city or beyond.
I doubt if the average property owner even knows that he has to renew that every 20 years,
That's what I'm saying, there's no protection.
Most of us. But
We wouldn't be protected, we would not know that somebody's, because we haven't renewed it, and somebody's putting a line through us.
One of those situations where you snooze, you lose,
Yeah, well, yeah, but do we notify all the residents every 5 years? Don't forget, renew your mineral rights. I'm just thinking, I gotta think like a guy trying to make a buck out of his well, and if he's got the capability to go far,
It
he's
can be
gonna go far.
very lucrative to,
Okay.
mineral rights.
Just a thought, I don't know how you can handle it language-wise into our ordinance, but if you could do some digging on that and see what's best practice for other areas that regulate wells.
Yeah, we'll research that.
Thank you.
I wasn't really sure that the homeowner had to do that. I know, I have a piece of property up north, and Shell Oil had a mineral right under my property for a while, and, when I went and checked the law on it, it said if they don't institute some kind of drilling to find oil or something within 5 years, then their thing was null and void.
Does it go automatically back to the property owner then?
Yes, it does. That was my understanding. I mean, one of the state legislators up there, and this is in Benzie County, they were the ones that put out a pamphlet. It was at the courthouse one day, and I was looking at it, and it made me feel a lot better because this mineral right was already on the property when I bought it, and it had been several years and nothing had been done with it. So that made me feel real good that, especially when you're around water, because if that lake or that groundwater, what you want to call, like whatever you want to call it, tag onto it, became polluted anyway, your property is not only worthless, it's a minus.
There,
Gonna cost you.
in the last time we talked about this, I passed out basically a white paper that we wrote.
Right.
And in there was a lot more detail in terms of property rights and
I
human
remember,
rights.
yeah.
So maybe we can reference that for more detail.
Just put something in language in our ordinance to make it easier for, let's say, a resident to read it and say, oh, I understand that, I don't have to do this, or I do have to do this.
Yeah.
Well, this could very well be controversial, at least it has been in other.
Well, I'm not sure, and I'll have to check with Alan. There are state and federal. Now we're starting to get to state and federal
I
laws in
understand
terms of
that, I understand it could go into that, but something for a Troy resident to say, looking at our ordinance and get a good handle on what could happen to my property or not. That's all I'm saying. And I realize maybe our ordinances don't do that necessarily, but I thought we're always trying to make things easy for a resident to just pick up our ordinance and read it and understand it. And I thought maybe that might be helpful to put in something of that effect.
Well, if we're getting into the state's purview, then I think that could be a slippery slope.
Well, we can reference that state thing, you know, I'm just saying, we don't have to write the language, we just allow the resident to understand.
I'm sorry, but you're you're asking us to put a statement in here that says,
Well,
that states that residents have the,
well, basically, for mineral rights, refer to this state statute or whatever it's called, so that you know what your rights are with the minerals underneath your ground. So, I don't know, you know, I'm not wording it today.
So what we'll do then is Alan will research it,
Mhm.
and we'll let you know what the findings are,
Okay,
and we'll discuss it,
good.
and come up with a solution that
Thank you.
everyone's comfortable with. If it works, we'll do it. If it doesn't make sense,
Thanks.
I hear what you're saying.
And then there's nothing to prevent property owners from selling their rights, so their subsurface rights if they have them,
That's true.
so,
Yeah.
and that, which is probably gonna happen.
Mhm.
Especially if one well goes in.
Yeah.
Anyone else?
So are we pressing in the right direction?
Yeah.
As far as I'm concerned, you are,
Okay.
right.
If anyone has typos, punctuation,
Legal.
This is just a draft. This is just a draft. It doesn't
we're happy,
even matter.
now's the time to give it, we're happy to.
Yeah, doesn't, my only comment would be, and I have never drafted a piece of municipal legislation in my entire life, so I do not know. But my suggestion, if I had one, would be to avoid words like reasonable, or where practicable, or any place where you could give people an invitation to argue what the definition of that might look like.
that's the backbone of zoning ordinances. Unfortunately.
Well, right, I mean, possibly, but you had one up there where it said that we had, you know, the opportunity to, under a special use, to do things that were reasonable. I would just rather it say that the planning commission may make additional requirements and leave out the part about whether or not it's even reasonable, but we may be able to do that, or we have the right to do that.
It's the problem is state law uses language like you can impose reasonable conditions and.
Right, state
Well, like I
law.
said, I have never drafted a piece of municipal legislation in my life, but if I'm all about taking out language that invites discussion about what it should mean or how it should be defined.
Anyone else?
Well, so I think, we'd like to bring something back quickly, because we kind of have the momentum rolling on this, so, maybe in December, we can bring back a
Great.
ordinance draft copy.
We'll put it in ordinance form, we'll get it to Lori, we'll redo that research, then we'll.
Is the city manager aware that this is?
Yes.
Okay. The only thing else we have is public comment for items not on the current agenda, and there's seeing no one here, so we'll move on to planning commission comments. Let's start with Mr. Tagle tonight.
I'm good, thank you.
Mr. Stratt.
Are we having a meeting on the 23rd? Next month?
It's scheduled,
It is?
it's scheduled. But if there's nothing pressing, then we,
We were gonna hold a public hearing for this that night.
yeah.
Okay, I just wanted to know.
You want to
I-
plan
I-
accordingly.
I like the grass that's, we got at, on Coolidge, or Crooks Road on Big Beaver.
You like it?
I think it's pretty tall, don't you think? They should cut it down.
Well,
Oh, grass, perennial grasses?
yeah, the
Yeah.
grass is,
They're supposed to stay up.
Pardon me?
well, when the
Perennial
snow hits,
grasses.
they'll push them down.
Yeah, no, I'm
It's-
getting it right now. It's like nothing is there.
Yeah,
Unfortunately, I was kind of disappointed. I thought they would be planting a little bit taller grass than what they had, but,
When I
Are we
saw,
talking- Are we talking perennial grasses?
We're talking about native grasses that are very durable and
Right,
they're at the Kelly Services Building.
right.
Yeah.
Did we talk about this at the last meeting?
No, it was one.
Yeah,
of
you
the-
brought it up, you said
Yeah.
that they wanted to put it in.
Yeah, it's a different
Yeah.
approach,
Yeah.
and I actually called, the landscape
Yeah,
architect.
Yeah,
I actually called him. I said, like, you sure about this? He says, no, they afford it. They're good. They're durable.
yeah, well, there are different species too, some are tall, some are
Yeah.
not. Some, I'm just hoping that it's gonna be a taller version.
Carl Forster, I don't know, remember seeing the plant, do you guys get the plant list?
Mm-hmm.
But Carl Forster is a really narrow and tall grass. It was perennial over the year for several years straight. And that's the big advantage. You don't wanna cut those grasses down in the wintertime, because that's where they provide
No,
the
these
screen.
are real small, they haven't cut them down.
Well, if they grow, they get big too.
There's different species,
I know.
they're different heights, they're not all the same.
All I can say to that is I'm no expert on plants, but they were just planted. So I would say like next summer's when you really
I'm
want to.
hopeful that
Yeah.
that's gonna be the case, yeah.
Typically, you cut them down in the spring, early spring, so they grow again, so they have all new growth. Okay, anything else? Let's see, where did we get to? Ms. Cruz?
I just want to wish everyone a nice Thanksgiving holiday with friends and family, and look
Thank you.
forward to seeing everyone next month.
Everybody be safe.
Yes. Val?
Happy Thanksgiving, everyone.
Yes.
The 23rd, if there's nothing pressing, we won't have a meeting, but if we get applications or whatever, we'll proceed. Right now, it's looking like we may not.
Good.
Ben?
Happy Thanksgiving.
Okay?
Kathy?
Thank you.
We're adjourned, folks. Good holiday.